Thank you for joining Ask an Expert. This morning we'll be talking with Jennifer Donovan around guardianship and conservatorship. Jennifer is the public guardian for the state of Iowa and oversees Iowa's Office of Public Guardian. She received her law degree from the University of Iowa College of Law. Prior to joining the Office of Public Guardian, she practiced law for 11 years as staff attorney at Iowa Legal Aid. She's a member of the National Guardianship Association and the Iowa State Bar Association. So thank you, Jennifer, for joining Ask this morning.
Well, thank you for having me, and I'll just go ahead and dive right in. We'll talk a little bit about guardianship and conservatorship, what they are, how they're initiated, and kind of how they work. Before we get into that, though, I'll give you a little bit of background about what the Office of Public Guardian is and what we do. The Office of Public Guardian is housed within the Iowa Department on Aging, but don't let that fool you. We do serve adults of all ages, 18 and up. There are three main functions that the Office of Public Guardian performs. So one of those is that we actually serve as guardian and conservator of last resort for Iowans 18 and older who have no one to serve in that role, don't have resources to compensate a private guardian or conservator, and whose needs can't be met by less restrictive alternatives than guardianship and conservatorship. We also provide information and referral to the public about guardianship, conservatorship, and alternatives. So that's things like doing the presentations like this, as well as less formal answering questions by phone or email about guardianship and conservatorship topics. And then we also provide some training and education for guardians and conservators, both to help them understand their responsibilities in that role, as well as helping them find resources that they might need for the folks they serve. We'll start out by just talking a little bit about guardianship and conservatorship and what they are. Both guardianship and conservatorship are legal processes where the court appoints someone to make decisions for a person who is not able to make or communicate their own decisions. The person for whom a guardian or conservator is appointed is called the protected person. Previously, you may have heard the term ward used, but there were some changes to the guardianship laws in Iowa that went into effect January 1st of 2020. And one of those changes was to that terminology. So now the word protected person is what we use, and so that's what we'll use throughout this presentation. A lot of people want to know, okay, what's the difference between guardianship and conservatorship? Or they have some confusion between those two terms. The main difference between a guardian and conservator is the type of decisions that they make for the protected person. So guardians make decisions about the protected person's physical care. That would be things like housing, education, employment, healthcare, services the protected person might need. Conservators, on the other hand, will make decisions about the protected person's property and finances. So things like their money, their property, their investments, making sure that the bills get paid, those types of things. I want everyone to think back to their 18th birthday and think, were you excited to finally be an adult? I definitely was. And if you think back, what was it that was so exciting about being an adult? Like most people, you were probably excited to finally be able to make your own decisions. And decision making is a basic legal right. All adults are presumed to be competent, which means they're presumed to be able to make their own decisions. Of course, people don't always make good decisions. Everyone makes bad decisions now and then. Some people make a lot of bad decisions. We can all probably think back, just like thinking about our 18th birthday, we can probably think back on some of those decisions that we've made that maybe weren't the best. Maybe we knew going in that they weren't great decisions, or maybe it turned out, later with hindsight that they weren't great decisions. But just because an individual makes bad decisions, that doesn't mean that they should lose their right to make their own decisions. a lot of times folks will think that, having a disability automatically means that someone will need a guardian to make decisions for them. And it's true that sometimes an injury or an illness or a disability can affect a person's ability to make decisions. They might need help making decisions, or they might even be unable to make their own decisions. But just the fact of having a disability, or even having a certain kind of disability, doesn't automatically mean that a person will need a guardian or conservator. Before the court will decide that a person needs a guardian or conservator, the court must find that the person meets a legal standard. And the legal standards for guardianship and conservatorship are similar, and we'll look at both of those in just a minute. But both of them look at whether the person's decision-making capacity is impaired. So I want to talk a little bit about what that means. What is decision-making capacity? Decision-making capacity refers to the ability to do four things: to understand information. So that's the ability to learn information about a topic. The ability to appreciate how it applies to the person's own situation. The ability to use reasoning, things like weighing the pros and cons of different options. And then the ability to make and communicate a choice based on that process. So the ability to then express that choice. And we can think about that. An example that I usually use is, let's say that someone is diagnosed with diabetes. So understanding would mean the ability to learn information about diabetes, that it's a condition that affects your blood sugar. It has certain symptoms, certain kinds of treatment, certain effects on the body. Appreciation is then the ability to apply that information to their own situation, to say, oh, I have diabetes and here's how it affects me. Here are the medications that I have to take. Here are the things that I'm supposed to do with my diet. Here's how I feel, in different situations. Reasoning might have to do with making choices about what type of treatment to follow, what type of diet to follow. Should I eat this? Should I not eat this? Should I take this medication or that medication? Weighing out, what are the pros and cons for each of those, because they'll each have pros and cons. And then expressing the choice would be saying, yep, I'm going to go through with this particular treatment, or no, I don't want to take that medication because of, X, Y, and Z reasons. So that kind of walks through, okay, what is the decision-making process that folks would use? Some people will have disabilities that affect their decision-making capacity, but they won't necessarily need a guardian or conservator. We'll talk in the next webinar about some of the legally recognized alternatives to guardianship and conservatorship, but these are a few things that anyone can use to help someone increase their ability to make decisions. The first three strategies can help people better understand information. Sometimes it's really not a matter of an inability to make decisions. It's that they don't have all of the information, or they don't understand all of the information because it hasn't been presented in a way that's understandable. So one key thing is explaining things in plain language, avoiding using jargon or technical terms, explaining what those mean if you do have to use them. As a lawyer, definitely guilty of this. We have a lot of very specialized terms, lots of legalese. Doctors are another profession. Medicine has a lot of very specialized language that isn't necessarily easily understandable by folks without that training. And so putting things in language that someone without a lot of specific training is going to be able to understand is really important. Another thing is asking questions to ensure understanding. Sometimes we'll be talking to someone and explaining things, and they're nodding along, like, yeah, I'm getting it. And then they ask something or say something, and you realize that no, they really weren't getting it. And so stopping periodically and asking a question, preferably an open-ended question. If you ask, does that make sense? They'll nod and say, yep. But if you ask them to repeat something back or explain it back, then you'll start to see, where did that understanding kind of break down? And then you can try to re-explain, maybe in a different way, help them understand better. A really crucial one for dealing with a lot of folks with disabilities or older adults would be making sure that any needed communication supports are in place. So if you have someone with a vision or hearing or speech impairment, they might need materials in a different format. You want to make sure that, if they need their glasses or hearing aids or an augmented communication device, that they have those, readily available. Someone who uses a sign language interpreter, you want to make sure that they have access to one when they're communicating about important decisions. If you have someone who doesn't speak or understand English, maybe English isn't their primary language, they might need an interpreter who speaks their primary language. Turns out they understand the information just fine. It just wasn't being presented in the language that they understand. So overcoming some of those sorts of barriers to communication is kind of a prerequisite before you can say someone doesn't have the capacity to make decisions. Another thing to think about is that decision-making is a skill, just like any other skill that we learn. And the more that people practice it, the better they get. So sometimes folks might need extra help practicing this skill, and the next 3 strategies can help with that practice. If someone's having trouble applying information to their situation or weighing pros and cons of different options, it might help to use social stories and personal examples, because sometimes having that concrete example of how someone else made a similar decision can help a person make sense of some of those abstract ideas. Another thing is breaking a decision down into smaller steps. Many big decisions don't need to be made all at once. So you could look at a decision, do you want to move to a different apartment? Well, maybe. How do I know? Well, let's start by looking at what things you like and don't like about your current apartment. What things would you want in an apartment? Look at other apartments to see if there are ones that have more of the things that you like. Look at your budget to see what you can afford. Break it down into each of those pieces, and then start going and seeing other apartments. And then you start to get more of the information that you need and work your way through that process to make the decision. Nope, actually, I'm happy where I live now. Or, yeah, I think I do want to move. And here's where I think I want to move to. And then if you're helping someone learn to make decisions, you can model how you go through the process of making decisions in your own life. So parents do this naturally with their children, teachers do it naturally with their students, kind of walking through those processes, just on a day-to-day basis. How did we decide, whether to go on vacation? How do we decide what to have for dinner? How do we decide what to wear today? All of those types of things, demonstrating that process and involving the person in that process helps them, learn those skills over time. So now let's talk about that legal standard that I mentioned earlier. This is what the court is looking at when they're deciding whether or not someone needs to have a guardian. In order to find that a person needs a guardian, the court must find that the person's decision-making capacity is so impaired that they're unable to care for their personal safety or to provide for their basic necessities, such as food, shelter, clothing, or medical care, without which physical injury or illness might occur. And the legal standard for conservatorship is similar. In order to find that a person needs a conservator, the court must find that the person's decision-making capacity is so impaired that the person is unable to communicate or carry out important decisions concerning the person's financial affairs. Now, it's important when we think about these things that we really think about that decision-making capacity. A lot of times folks will have difficulties functionally carrying out those things. They may have a mobility impairment, or they may have difficulty with fine motor skills that makes it hard to actually do independently all of their own activities of daily living, whether it's dressing themselves, whether it's, running errands, various different things. That functional ability to do the task is different from the decision-making capacity involved with saying, I know that the task needs to get done. I know that this is a need that I have, and I can't personally do it 100% independently for myself. So here's how I'll make sure it gets done. I will have someone help me with it. I'll have someone give me a ride. I'll have, I'll wear clothes that are easier to put on, or I'll have someone help dress me. So it's important to look at the difference between that functional ability to do the tasks versus the decision-making capacity to understand that that's a task that needs to be done, and it may need to get done in a little different way for me, but I can decide how it gets done and I can direct that, so to make sure that it does get done. So before considering guardianship or conservatorship, there are a couple of important things to consider. The first one is going to be, asking, does the person meet this legal standard? If they don't, then they don't need a guardian or conservator. And so it's not going to make sense to file that petition with the court to have a guardianship or a conservatorship established, because the court's probably going to say this isn't necessary and end up dismissing the case. The second thing to look at is, are there less restrictive alternatives that could meet their needs? Both guardianship and conservatorship restrict a person's right to make their own decisions, while there are other options that allow the person to keep the right to make their own decisions, or that limit only their decision-making rights in certain areas. So some of these options are things like informal supports or supportive decision-making that are ways that others can help the person make decisions. Other options, like a power of attorney, let the person share their right to make decisions with someone else. And then things like a representative payee or a limited guardianship or conservatorship do restrict the person's rights to make some types of decisions, but then they retain the right to make other types of decisions. So it's always important to consider, is there a less restrictive alternative that might work? And then it's also important for the potential guardian or conservator to consider, are they prepared for the responsibility? Because being a guardian or conservator is a big responsibility. While not every protected person is going to need a guardian or conservator for the rest of their life, some do. So the guardian or conservator should understand that this is a long-term responsibility. If they're worried they won't be able to be guardian or conservator for as long as a protected person needs them, for example, parents who might be considering guardianship or conservatorship of a younger adult child, they may anticipate that their child will likely outlive them, or will likely need a guardian or conservator, past the point that they're really able to fulfill that role. Then they should make a plan for who's going to be able to take over when they're no longer able. A guardian or conservator also needs to understand their duties to the protected person. So they have a duty to make decisions for the protected person that put the protected person's interests first. This includes considering what the protected person would decide if they could make their own decision. It includes that the guardian or conservator shouldn't be making decisions based on their own personal preferences. The guardian or conservator also has duties to the court, the main one being to file reports or accountings with the court when they're first appointed, and then every year after that. And that keeps the court informed about their actions on behalf of the protected person. So let's talk a little bit about the process for establishing a guardianship or conservatorship. It starts with filing a petition with the court. And the petition tells the court basic information about the people involved in the case, who the respondent is, why it's believed that the respondent needs to have a guardian or conservator, who the proposed guardian or conservator is, and why they would be qualified to serve in that role. It also tells the court who else might need to know about the case. Maybe there are other family members or caregivers that are involved in this person's life that would have information that the court should know about, or that would have an opinion on whether or not a guardian or conservator is needed. The respondent has a right to be served with notice of the case and a copy of the petition. So they have a right to know that a case has been filed saying that they might need a guardian or conservator, and to see what's been filed with the court. The respondent also has a right to be represented by an attorney. So the court will appoint an attorney for the respondent, or the respondent can hire an attorney of their own. As of January 1st of this year, the court is required to conduct background checks on proposed guardians and conservators. They're not going to go back and do background checks on ones that were appointed prior to January 1, 2020. But anyone that's being appointed after January 1, 2020 will have a background check conducted that includes the Iowa Criminal Records, the Iowa Child Abuse and Dependent Adult Abuse Registry, and the Sex Offender Registry. The court will also schedule a hearing. At the hearing, the court receives testimony from witnesses and any evidence that might be documents or other things about why the respondent does or doesn't meet the legal standard to have a guardian or conservator appointed. And those are the things that will definitely happen in every case. There are some other things that might happen in a guardianship or conservatorship case between when the petition is filed and the hearing. The court might order a professional evaluation of the respondent by someone who is qualified to assess their decision-making capacity. This is likely to happen if there's not already an evaluation that's been done and submitted to the court, or if there's conflicting information in a couple of different evaluations that have been submitted, and the court says, hey, we want to have another one to try to clarify up some of those confusions. The court might appoint a court visitor. This is someone who can investigate the situation and make recommendations to the court about whether guardianship or conservatorship is appropriate, whether or not the proposed guardian or conservator is the one that should serve in that role, etc. The court visitor kind of serves as the eyes and ears of the court outside of the courtroom, so they can meet with the parties to the case. They can go see, where does this person live? Where do they work? Where do they go to school? And talk to the different people involved to make good recommendations. The court might also order the parties to engage in a mediation. This is not particularly common in more routine guardianship and conservatorship cases because there's not a lot that a mediator can do to address whether someone meets that legal standard or not. Mediation is most common in cases where maybe there's a family dispute or a disagreement about a particular decision that needs to be made or something like that, where having that neutral third party of the mediator helping, kind of go between and try to reach agreement on things might be helpful. If the court finds that the respondent's decision-making capacity is impaired enough that, yep, a guardian or conservator should be appointed, then the court needs to consider whether a limited guardianship or conservatorship would be appropriate. In a limited guardianship or conservatorship, the guardian or conservator only has the authority to make decisions in certain areas. A protected person retains the right to make decisions in all other areas of their life. So an example of this would be one that I think is fairly commonly used is someone with a severe mental illness that's pretty well controlled when they're taking their medications and getting appropriate treatment. During those times, they may be perfectly capable of making their own decisions about everything or mostly everything in their life. But if they go off of their meds, stop getting treatment, they might spiral down pretty quickly to a point where they're really not able to make decisions for themselves. So sometimes a limited guardianship is appropriate there, not to make all of the decisions for the person, but to have access to medical information, to be able to talk to their medical providers or their service providers to find out, hey, how are they doing, and keep tabs on them, and then to step in if things go badly to make sure that they get the help that they need. So that would be one example of when maybe a limited guardianship would be appropriate. And judges are required to consider whether a limited guardianship is appropriate, and that's been a requirement for many years. But in practice, we find that a lot of them don't unless someone involved in the case suggests it. They're kind of used to the more full guardianship or conservatorship. And so oftentimes they would only look at it for the potential of limiting if somebody involved in the case said, we think a limited guardianship actually is appropriate under the circumstances. And we're hoping that some of the changes with the laws that went into effect this year will help force the judges to look at each of the powers of the guardian and conservator individually and really craft them more to the individual situation. Say, okay, what decisions does this guardian or conservator actually need to be the one making in this particular case? If the court appoints a guardian for a person, there are a variety of different responsibilities that the guardian might have. The exact responsibilities will be spelled out in the court order appointing the guardian. So for service providers, it's really important to get a copy of that order and review it, because that will tell you what decisions the guardian is responsible for and what rights the protected person retains. Generally, a guardian's responsibilities related to the protected person's non-financial needs. So that would be things like making sure that the protected person's basic needs for food, clothing, shelter, and medical care are being met, making sure that they have access to any education, training, vocational, or other professional services that they need, and helping them pursue social and recreational activities and develop and maintain supportive relationships. The guardian's most important responsibility is to help the protected person develop and maintain self-reliance. So that's really going to be the thing that's the foundation on which all of those other responsibilities are built. When the guardian is making decisions for the protected person, they should involve the protected person in those decisions as much as possible, and they should make decisions with the protected person's goals, wishes, and preferences in mind. In May of last year, the General Assembly passed a bill, and Governor Reynolds signed it into law, that made some significant changes to guardianship and conservatorship in Iowa. And these changes went into effect on January 1st of this year. And the new law made some changes that clarify some of the guardian's powers that require specific court approval. So in the past, the law said that a guardian needed specific court approval to change the protected person's permanent residence if the new residence is more restrictive of the protected person's liberties. Well, this is confusing for a lot of people, because what does it mean for a residence to be more restrictive of a person's liberties? So the new law clarified that this refers to a nursing home or a secure facility or portion of a facility that's restricting the protected person's ability to come and go or have visitors. Previously, the law also required specific court approval before the guardian could arrange for major elective surgery or any other non-emergency major medical procedure. This was also confusing for a couple of reasons. One, because medicine changes over time. So what was a major elective surgery, 10 years ago or 20 years ago might be super routine now. And so it's hard to know, what is a major elective surgery or medical procedure. But it also didn't specifically call out certain things that guardians needed to not do without court approval. So the new law clarifies that sterilization and performance of an abortion on the protected person both require specific court approval. The one area that did not change is that guardians require specific court approval before they can consent to the withholding or withdrawal of life-sustaining procedures for the protected person. That one remained exactly the same. So another change that took place related to the reports that guardians file with the courts. Previously, guardians had to file an initial report within 60 days after they were appointed, and then an annual report every year, and then the final report within 30 days after the guardianship ends. Judges often waived those annual reports, so they might only require them every 2 or 3 years. Some would even waive them entirely. There were folks that had not filed an annual report at all. The purpose of filing those reports is to keep the court informed about what's going on in the guardianship. And problems with those reports, a late report or an incomplete report, those were often the first sign that the court has of problems with the guardianship. So the new law strengthened those reporting requirements. Judges are no longer allowed to waive the annual reports. The initial report has been replaced with a care plan. So instead of simply reporting on what's going on in the protected person's life at the time that the guardian is appointed, the care plan requires the guardian to make a plan for how to meet the protected person's needs over the course of the next year and beyond. For guardianships that were in place before January 1st of 2020, the guardian will retain all the powers they had under the old law until their annual report is due this year. At that time, they'll file the annual report covering last year, and then they'll also file an initial care plan. Even if they've been guardian for many years, it's still going to be the initial care plan, and they'll file that along with their annual report. after that, their powers will be based on the new law and whatever's needed to carry out that care plan. Now, if the court appoints a conservator for a person, there are a variety of different responsibilities that the conservator might have. And again, the exact responsibilities will be spelled out in the court order appointing the conservator. For service providers, it's again important to get a copy of that court order and review it, because that's going to tell you exactly what decisions the conservator is responsible for and which rights the protected person retains. Generally, a conservator's responsibilities relate to the protected person's financial needs. The conservator has what's called a fiduciary duty to the protected person, which means that they have a duty to manage and use the protected person's money and property for the protected person's benefit. The conservator can't spend the protected person's money on things for the conservator or the conservator's family or friends. Now, the conservator doesn't have to preserve the protected person's money and property for the future instead of spending it on things for the protected person in the present. I think a lot of times conservators feel like, oh, we must conserve this, we must keep it for the future and not spend it now. Really, the test is that the conservator needs to make prudent decisions about how to save or spend the protected person's money. They need to balance out those current needs versus those future needs. The new laws have made some big changes to conservatorship. And the biggest one is that most of the powers that conservators used to have kind of by default, they no longer automatically have. So most of the powers that they have are going to come only from what's specifically listed in the order appointing them. So that's going to be the biggest change. It's going to be extra important to look at those court orders. And existing conservatorship orders will need to be updated. In that same process with the guardianships, they're going to keep those powers until their annual report would be due this year. And then they're going to file their plan with the court for how they're going to manage the protected person's funds and property. And then that's going to be the basis for what powers they have going forward. Another change is that all conservators will be required to have a surety bond or a suitable alternative to a bond. This protects the protected person from the conservator misusing or mismanaging their funds. In the past, the court could waive the bonding requirement for smaller estates, ones of $25,000 or less, but that will no longer be allowed because it's realized that, if you misuse $25,000 or less, if that's all that the person has, that's going to be just as detrimental as, misusing a larger amount. And then the question that a lot of folks have when they're thinking about guardianship or conservatorship is, how long is this going to last? Guardianships and conservatorships are not always permanent, but they're usually long-term arrangements. If a person's needs are going to be really short-term, then guardianship or conservatorship may not be the best arrangement. There are basically 4 situations that lead a guardianship or a conservatorship to end. Guardianships of children, minor children, end automatically when the child turns 18. So if the child will need a guardian or conservator as an adult, then a new petition needs to be filed to establish that they will need one as an adult, because that legal standard is different. A guardianship or conservatorship will end when the protected person dies. It will also end if the protected person's decision-making capacity is no longer impaired. So either the guardian or conservator or the protected person can ask the court to end the guardianship or conservatorship if it turns out, the protected person's decision-making capacity is no longer impaired. They can make their own decisions now. They no longer need that guardian or conservator to be making the decisions for them. And then the court can terminate the guardianship or conservatorship if it's no longer necessary for any other reason. The most common one that I've seen here is when you'll have a conservatorship in place to manage certain money or property, and then that money is spent down or that property is sold. And so the need to manage that particular asset is no longer there. And so maybe then there are other alternatives. If the person has Social Security benefits as their only income, maybe they have a representative payee managing those. And so you might reach a point where there's no longer a need to have that conservator in place, even if the protected person's decision-making capacity hasn't changed. the nature of their assets or the nature of the decisions that need to be made has perhaps changed. So it may no longer be needed at that point. Another thing that a lot of folks have questions about is the cost. What does it cost to file a petition for guardianship? And I would love to be able to give exact numbers, but that's going to really vary depending on how complex the case is. As most of the costs are assessed against the respondent or protected person, petitioner usually only has to pay costs if the case is dismissed and if there's good cause for the court to order the petitioner to pay the costs. So that would usually be if there was no basis for a guardianship or conservatorship petition to be filed in the first place, and the court is basically saying, look, this was a complete waste of our time. This wasn't a good faith thought that this might be necessary. This was frivolous. Now, if the respondent or protected person is indigent, then the court costs can often be waived. And a lot of the other costs will be assessed to the county in which the case is filed. The big one that doesn't have a provision for waiver or for being paid by the county is the petitioner's attorney's fees. The petitioner's attorney will probably require the petitioner to pay their fees unless there's some other source of payment or the attorney agrees to represent the petitioner at no cost. So for a lot of folks, that's really going to be the biggest expense. It's worth looking into, whether you might be eligible for free or low cost legal services throughout the state, or talking with, friends or family or neighbors who've maybe gone through the process and can say, yep, this was the attorney that we used and they were willing to work with us on the costs and keep it pretty reasonable. Kind of getting those word of mouth referrals for ways to keep those costs down. So I do have a chart here that just breaks down some of the types of costs involved and then who pays for each of them. And you can see again that most of them are going to be charged to the respondent or protected person if they have funds, and then either waived or charged to the county if they're indigent. So I'd like to take just a couple of minutes real quick to go through some guardianship myths. These are some that are pretty commonly held and that I like debunking. So one of them is that most adults with disabilities will need a guardian. And that one's just flat out not true. A lot of folks will think that most adults with disabilities, and especially with an intellectual, developmental, or mental health disability, need a guardian just by virtue of having that particular diagnosis. But we have to remember that there's a legal standard that judges use to decide whether a person needs a guardian. And most people with disabilities won't meet this standard. Most are going to be capable of making decisions, even if they need some extra help or support to do so. And that there are some alternatives that can help with doing that. Because guardianship limits a person's rights, it should only be used when no other options will work. A related myth is that parents of children with disabilities need to file for guardianship as soon as their child turns 18. And certainly there are going to be some children who have such significant impairments to their decision-making capacity that it's known in advance they'll need a guardian when they reach adulthood. But for most young adults, it's worth trying less restrictive alternatives before filing for guardianship. Families can always file for guardianship later if the less restrictive alternatives don't work. And then they can at least feel confident that they've tried all of the options, because there are other ways for parents to remain involved in their young adult child's care without guardianship. And we'll talk about those in the next webinar. A third myth that comes up is that that older adults who are diagnosed with dementia will automatically need a guardian or conservator. What we find is that there are really different types of dementia that affect different parts of the brain and different cognitive skills. So it's important to look at the person and what they can and can't do rather than just the diagnosis. We also see that most adults are diagnosed fairly early in the dementia process. They may have some memory loss, but they may still be able to make most or all of their own decisions. And that's really an opportunity, in those early stages of dementia to take advantage of some planning tools to avoid the need for a guardian or conservator later on. Another myth that comes up really commonly, I get a lot of calls and questions that relate to this, is that guardianship will protect a person from making bad decisions. This one's really a myth for two reasons. First, Because adults have the right to make their own decisions, including bad decisions. So as long as they're capable of working through that decision-making process, the outcome might be a decision that someone else thinks that's going to be terrible, that's going to have disastrous consequences for you. But there may be things that that outside person doesn't know that are going into the considerations that the person is making when they make that decision. And so adults have the right to make those decisions even if they're not good ones. The second one is that a guardian can't control a protected person's behavior. A guardian can't force someone to eat certain foods or not eat certain foods. A guardian can't prevent someone from smoking or drinking alcohol or using drugs. A guardian can't force someone to take their medications or to cooperate with service providers. I always say you can sign them up for the services, but you can't make them answer the door when the service provider shows up. Likewise, a guardian can't stop aggressive behavior, consensual sexual activity, or just things like staying up late, sleeping late, skipping work or school, those types of things. The guardian may be able to put in place, certain structures or services or things to try to address those sorts of behaviors, but it's not something that guardians have a magic power to be able to stop. A final myth is that guardianships and conservatorships are a lifelong prospect. And we've talked about that. There are a small number of people with very severe or progressive disabilities where that very well might be true. But many people who have guardians can learn decision-making skills and limit or end their guardianships. And in fact, I would argue that terminating or limiting the guardianship should be a goal in most cases. You may not actually meet that goal, but it should be something that you're working toward because guardians have that responsibility to help their protected person become self-reliant. And they can do that by involving the protected person in decision-making, giving them the opportunity to make as many of their own decisions as possible, and really maximizing their self-reliance and their independence. So before we wrap up, there are a couple of really good resources out there for guardians. There's locally here in Iowa, there's the Guardianship Association of Iowa Network, which is a nonprofit membership organization that works to enhance the professional education and networking opportunities for Iowa's substitute decision makers. It started out initially as an organization more for professional guardians and conservators, but there are a lot of other service providers, and they're really looking to branch out and have more family member and volunteer guardians getting involved as well, and to provide more programming and services for those folks. And then on the national level, there's the National Guardianship Association, which is a national organization dedicated to improving the standard of excellence in guardianship. Both organizations have excellent conferences that they put on and other educational and informational resources available. So those are both definitely worth checking out if you are a guardian or are considering pursuing guardianship in the future. And then I will leave here at the end with my contact information. So if folks have questions and want to reach out, I am always willing to take calls or emails and try to answer those questions.
Thank you, Jennifer. Great information on the foundation of guardianship and conservatorship, and also updated the 2020 laws. I think that was very important. So thank you very much. Myths were also very helpful so that people can begin to unlayer what is it and how do they support the process as they journey with that person. So I do have a question for you from one of our audience members. They asked, how many people does the Office of Public Guardian serve as a guardian for?
So currently we have, just based on where our funding level is at, we have the capacity to serve about 60 to 65 individuals. And so we're running at that capacity pretty much continuously.
Sure.
And those are folks all over the state. We do have a waiting list. There's quite a bit more need for the service, but that's about how many folks we're serving right now.
Another question for you. Is it true that a person has a guardian that they're not able to vote? Could you clarify that for us?
No, that is not automatically true. And that's another one that I really ought to add as a common myth. There's a provision for adults with intellectual disabilities that the court could determine that they don't have the capacity to understand voting. And so they could say that that individual does not have the right to vote. But that's not automatic. Most folks do have the capacity to understand what voting entails, how to vote. They may need some help to gather the information about candidates or to think about issues that affect them, or to actually physically mark a ballot. And there's a lot of work to make sure that, voting is accessible to folks. But that's one of those, check that order to see, because that's one of the things that should be specified in every guardianship order, whether or not the person retains the right to vote. And if you're working with someone that you think should be able to vote, but their order says that they can't, then that's potentially a time to go back to the court and say, hey, we think this was done in error, or we think they've developed this ability since the guardianship was entered, and we want to make sure that they're able to cast their ballot.
So another question for you. What would happen if a guardian is appointed and then the guardian isn't able to continue to provide that support and nobody offers to do it?
So that's a challenging situation, and is part of the reason that our office exists. If there are financial resources available, there are some private guardianship and conservatorship service providers throughout the state. Sometimes it's a matter of finding a volunteer or someone locally in the community. But when there's no one else, then that's when our office gets involved.
Okay, all right. Well, thank you, Jennifer. I really appreciate your time and expertise on this, and we look forward to doing another one with you about alternatives to guardianship.